Welcome, everybody, to my summary of what we've seen in regulatory enforcement in the Biden administration in the first 100 days. Just as some background information and kind of as a foundation of where we may end up. In 2019, $3 billion was recovered by the federal government under False Claims Act recoveries. Or False Claims Act challenges or claims. $2.6 million of that amount was involved healthcare claims, leaving just $4 million for everything else. The military and everyone else that has such a bad reputation of gouging the government, only $4 million came from something other than healthcare, which to me is kind of astounding, which also shows that healthcare regulatory enforcement is good business for the government, having brought in $3 billion. That number took a significant hit in 2020 when the government only recorded $2.2 billion under False Claims Act enforcement, and 1.8 billion of that was in healthcare. Interesting that still leaves $4 million recovered from all other areas of life other than healthcare. So that has remained stable, but there was a significant reduction, $8 million reduction in what was received by the government. Most of that, as you can probably figure, is attributable to COVID-19 shutdowns, and the waivers that were issued by the government, and the lack of enforcement of certain provisions as well. So now, with at least some of the shutdowns easing in 2021, we want to look at how regulatory enforcement looks under the new administration. So today I want to go over what we have seen, what has happened, or what we've seen, what has changed, and then what we should expect under the Biden administration. So first, let's talk about what we've seen. Most everything we've seen so far to date has been a continuation of actions and enforcement that was initiated under the Trump administration. Obviously, that's not so surprising, given that we're just 3.5 months into the new administration. So a lot of the resolutions and the settlements were actions that were initiated under the Trump administration, with some new things being brought. We have seen some reduced recoveries continuing, though. For example, we have seen reduced enforcement in Stark claims. There were some new rules from the Trump administration that broadened, to a certain extent, the permissible arrangements under the Stark law, and allowing more collegiality between hospitals and doctors. So to a certain extent, that may have resulted in the reduced enforcement. There's also been a redirection of enforcement focus due to COVID-19 enforcement activities. But the Stark law is still out there, and enforcement will continue to gear back up, I believe. In addition to reduced enforcement with Stark law claims, we have also seen that there have been no reported Medicare strike force actions. These are reported by the Office of Inspector General of CMS on its website. And since the inauguration day, we have not seen any reported strike force actions. Again, probably due to the reasons we discussed. We have also seen fewer civil monetary claims and affirmative exclusions reported by the OIG, which is, again, also interesting, but it does show a couple things. One of them being the focus of the Trump administration during 2020 and where enforcement efforts were focused. So there are just minimal actions in that area reported on the OIG site. And I guess we should stop here and note that the leadership of the Office of Inspector General, which is the OIG, has not changed. Attorney Christy Grimm is still leading the office, although at one time I think her title was interim Inspector General. Now she is designated as the principal Deputy Inspector General, but she's still the senior person in the office. She did butt heads with President Trump with some of her reports. I'm not sure of her relationship with President Biden or the new administration, but my impression is that she handles the job well and has maintained her independence from the administration and stayed above the political fray. So what else have we seen? Well, we have seen the decreases in those areas, but we have seen something of maybe not an increase. My arrow there points up, but that's probably not the best thing. It should be a steady arrow because there has still been a lot of enforcement in some of the traditional areas that we've seen. The DEA is still very active. There is a lot of action on opioids, in kickbacks, as usual, in which someone's offered something in value in return for a referral, which could be paid in full or in part by a federal program. There has been an increase in telehealth actions, probably mostly because the usage of telehealth platforms has increased during COVID-19. And with a lack of structure and a lack of continuity, it has lent itself to a certain amount of fraud. So there has been increased enforcement in the telehealth area. Fraud is always going to be enforced. When you have a clear case of fraud, true fraud, and true misrepresentations, that's always something of a low-hanging fruit that can bring in a huge return. So that will always continue to be pursued. There's been pursuit of white-collar crime. Antitrust activities are still ongoing in mergers and consolidations, frequently between insurance companies. We have a pharmacy company also wanted to buy an insurance company and things like that. So there's additional scrutiny there. There's been additional scrutiny in the bidding process, especially with durable medical equipment, but in all government contracts where bidding is required. So they're still monitoring that. And with private equity transactions, before the pandemic hit, and we've done some webinars on this here as well, private equity was something of a rage. There was a lot of private equity acquisitions of medical practices and medical facilities, and that had tailed off a little bit with the pandemic, but not completely. And I don't think the government has much trust in these private equity ventures. They've not stopped them. They really can't stop them. And I think they recognize in some cases they may bring value. But the government's always worried about what the impact of these type of arrangements are going to be on Medicare and government beneficiaries, and whether or not they will be carved out of care provided by these newly held companies or practices, as well as whether there's going to be payment for referrals and things like that. as a lot of these private equity firms don't have a lot of depth in health law. So there's not a lot of trust there, and there's action there. But as you can probably guess, the primary area of enforcement has been in regard to COVID-19. In 2020 and on into this first quarter of 2021, the government has provided $5.4 trillion in relief. So, with that much money going out, the government's going to want some of it back. A whopping $178 billion of that amount was paid out in provider relief funds, both under the CARES Act and under the CRRSA. So that's a lot of money. And so I think we can anticipate that the government will be seeking to get some of that back. The government's skepticism of the use of provider relief funds has already started, although there's not really been any enforcement in that area yet, since practices have not yet been required to provide reports on how they used the funds, and the audits have not yet begun in the healthcare arena because the reports aren't due yet. Once the reports get filed, then I think the government will start using some analytics to decide who should be audited in regards to the use of the provider relief funds. There are a number of areas in which enforcement has begun under the CARES Act, such as in unemployment fraud. So we know the enforcement is coming. It just hasn't started yet. There has been one case under the CARES Act which resulted in criminal penalties, and that was an owner of a home health agency who shut down her agency but subsequently received her provider relief funds because the agency had been a Medicare provider. She got the funds, kept the funds, and wrote a bunch of checks to her family members. So she was prosecuted for that, and they did reach a plea agreement. My opinion is that kind of scenario is going to continue because, I think when that amount of money hits your bank account, it's hard to say no. So I think that will be a common scenario. In fact, although I don't know it for certain, I think there are some practices that I've seen down here in South Florida that they may be faced with that same scenario. Same thing with PPP fraud, Payroll Protection Act funds. There have been some settlements there for improper use of those funds. So we have seen some enforcement with the payroll protection funds, the EIDL, which is the Economic Injury Disaster Loans, unemployment insurance. In those three areas, there has been a steady practice of enforcement for fraud and misuse of funds. As I mentioned, provider relief funds, although a significant number, there has not yet been any enforcement there yet. But overall, in COVID-19 enforcement, there have already been 500 criminal cases filed. And actually, that's 500 different individual defendants. And there are, and the reason those cases have been filed is because just in those 500 cases, $569 million of federal funds are at issue. In other words, in those 500 cases, the total is $569 million at issue. And the government, wants it back. So those will continue to be hotly pursued. And recognize also that in these criminal cases, if the government is able to make out a claim that the defendant violated the False Claims Act, not only will the government get back let's say in theory that all 500 criminal cases involve false claims act liability, they could get triple the $569 million back from those defendants, as well as treble, as up to, I think it's $11,000 for every claim that was submitted. So it's a big number already, and when you add the multipliers, it gets even more significant. And as I said before, the provider relief reporting and subsequent auditing has not yet begun. It's just interesting to me, and will be interesting to see how it plays out, because we don't yet know. But these were funds that were part of the CARES Act in order to help Medicare providers continue to keep their doors open and to provide care for their patients. There was no application process. There was no request process. It was basically, here's a bunch of money based on what you had received from Medicare in years prior. So the providers didn't ask for these funds, but they got them anyway. When they hit last year, I had multiple calls from client providers, asking me, where this money came from and what they're supposed to do with it. Of all the things in the CARES Act, the provider relief funds probably had the least amount of guidance to go with it. So not only did you get a bunch of money you didn't ask for, you're being told that you have to give it back, or we'll take it back if you don't use it the right way. But the government really didn't give a whole lot of direction on how it could be used. Now, subsequently, they have given some additional guidance. So I don't see a universal problem with the use of the provider relief funds absent of fraud, but know that it's going to be out there. And the larger amount, the providers that receive larger amounts of the funds are probably going to be much more subject to auditing. And of course, those who received it and then closed their practices are probably going to be the ones that are in the most imminent risk of having to return the funds. But right now, throughout the government, I think COVID-19 is the most active enforcement area across the board. But since the provider relief funds remain out there, unreported and unaudited, I think in the area of healthcare, they have not yet scratched the surface. So that's kind of what we've seen happening now in regards to enforcement. Before we jump into what to expect, I think we should talk about what has changed, because I think that's what's going to trigger what we see going forward. To me, and as you know, as President Biden is demonstrating in this picture, it's changed just a little bit. But to me, one of the primary things that has changed is the enforceable standards. In other words, what standards will be used by the regulatory agencies, both Health and Human Services or the DEA, and of course the Department of Justice, in enforcing these regulatory things. Under President Trump's administration, they made a conscious decision to only enforce violations of the healthcare statutes and their related regulations. That I don't mean to minimize that, because as we discussed earlier, the government recouped $3 billion in 2019. So it wasn't that they backed off on enforcement, but they rather chose to enforce only statutes and the related regulations. That policy was memorialized in an executive order that the president entered, and was also specifically written into the Department of Justice Enforcement Manual. However, in one of the first batch of executive orders that President Biden entered, he rescinded that executive order, or that portion of the executive order, which opened the door to broader standards, or broader things that providers could be accused of violating. Obviously, statutes and regulations are first on the list, and they will always be subject to enforcement. So that's the same as under the Trump administration. However, under the new policy implemented by President Biden, sub-coverage statements, guidance documents, instruction manuals, and things like that could also lead to enforcement actions and potential liability. I've actually seen that personally used when a Department of Justice lawyer asked a deponent in a deposition about a line from a Medicare provider manual. In the case, the contracts and the arrangements, at least in my opinion, that the defendant had set up, clearly met the requirements of the Stark and anti-kickback statute, as well as the relevant regulations. However, there was a line in a Medicare manual that didn't seem to fit that structure, and the Department of Justice attorney tried to use it against the witness to prove that indeed those laws were violated. So it's very overreaching policy. In my opinion, it's an unfortunate policy, and there's not a whole lot of case law on it as to whether or not that kind of statement by the government, which does not have the force of law or even a regulation, can be used to prove a violation of the law. So you may have nothing that in your arrangement that violates a statute or the regulatory language, but an offhand line in a manual may be used to establish a false claim, which again can lead to the treble damages and fines and penalties and attorney's fees on top of that. So in theory, if a manual says you have to use blue paper, and when you submit a report and you use orange instead, it could be an FCA, False Claims Act violation. Can be very dangerous and overreaching policy. So it's something to watch out for, to see how frequently the Department of Justice elects to use those non-statutory, non-regulatory standards. The other big change in the area of healthcare policy and resulting in enforcement is in leadership. As I mentioned, leadership in the OIG is pretty much the same. I don't think there's been a nominee for Inspector General, so right now Christy Grimm looks like it is her job to run the office. But there are others at the top who set policy and direction, who have changed, and I think knowing about them can help kind of know what to expect with future enforcement. The first change is that Merrick Garland is now the Attorney General. He has not said a whole lot about healthcare enforcement, but he has referred to regulatory enforcement as an historic initiative, at least in regard to the COVID-19 enforcement policies. So he does it does appear like that he intends to support enforcement of healthcare and other regulations. We should note here that although the Attorney General and the Department of Justice have significant power when it comes to enforcing any regulations, they are pretty much dependent on the agencies themselves and what the agencies want to see enforced. So if a claim is going to be brought under the Stark Law or the anti-kickback statute, then it's probably going to come from an agency up to the Attorney General. It's not anything that the Department of Justice on its own is going to pick up, absent some kind of criminal activity or fraud. But since a lot of these healthcare regulatory enforcement actions involve Medicare, and Medicare falls under ultimately the Department of Health and Human Services, that's a significant agency we need to watch. And of course, there has been a change there too. Alex Azar, who was with the Trump administration throughout the entire 4 years, has been replaced by Javier Becerra as the Secretary of Human Services. So, who is Mr. Becerra? He was the Attorney General in California for the last 4 years. Prior to that, he was in the House of Representatives for 24 years. So he is something of a career politician, has spent most of his career working in the Washington, D.C. environment. So he understands the political influence that can come about in initiating enforcement actions. However, he is married to a physician. His wife is a neonatologist, so he's not been isolated from the real world, and so he probably has some understanding of the healthcare regulatory environment that is involved or imposed upon medical practitioners. As far as his history goes, I expect that, looking at California as well as his track record in Congress, I think we'll see a focus on anti-competitive activities, such as with the antitrust. I think he'll watch for collusion amongst providers. He has been active in insurance payment issues, price transparency, and I think he has some skepticism over the benefits of practice, not necessarily practice, but vertical or horizontal consolidation. He has already, unlike Merrick Garland, who hasn't said a whole lot about healthcare enforcement, he has given a hint over what we can expect by saying that he anticipates robust enforcement. He hasn't given much more detail than that. He's only been in the position for, I guess, he's past his month anniversary, so there's not a lot. He's not had the opportunity to demonstrate what he intends to do. But just that term, robust enforcement, which is his quote, leads me to say, it's time to buckle up and be ready for some significant enforcement actions. There have been a couple other things that have changed. There has been recent legislation that narrowed the antitrust exemption for insurance companies. I don't think that affects providers too much directly, other than who the payors may be that you deal with. And there's also this HHS, Department of Justice, Office of Inspector General False Claims Act working group. This started under the Trump administration. I don't know that there's been a whole lot yet that's been done as part of the working group, but it's meant to provide coordination and cooperation between those three agencies in enforcing False Claims Act actions in the healthcare arena. So I do expect we'll see increased activity from this working group as the pandemic subsides, and those three groups kind of shake off the newness of the folks heading up those departments. So given what we've seen so far in the first 100 days and the changes that have happened within those first 100 days, let's talk about what we should expect. Obviously, starting off, robust enforcement across the board, using Secretary Becerra's language. I think we'll see scrutiny over antitrust consolidation. Again, insurance companies, health plans, pharmacies, maybe some private equity issues as well. We'll see the Federal Trade Commission take action in those areas. And I think we'll have the FDA will continue its scrutiny of pharmaceutical companies. I think we'll also see some, what I put in quotes there, consumer protection actions. I'm never sure these actions truly benefit the consumers, but it gives the government, a mantle in which to wrap itself, taking these actions. One of the first things I think we'll see a lot of enforcement on is price transparency. That will be a big issue. Already a group of, I think it was congressmen and senators have written a letter to Secretary Becerra asking him to investigate price transparency issues and make them a priority. As you know, hospitals were required, as you may not know, hospitals were required to post things on their websites, showing what their pricing is, what their reduced pricing rates were, their negotiated pricing and things like that for common procedures done at the hospital. That's an hour seminar that I've just tried to give you in a couple of sentences, but hospitals are required to now put their pricing out to the public, again, trying to avoid surprise bills so that patients understand what they're being charged for. It's a huge issue. It's a very political issue. I think the way it's played out in the few months that this requirement has been in place, it shows it's more of a political issue than a practical issue, because I think patients still, or potential patients, are still having trouble kind of figuring out how the rates are calculated and the data that the hospitals have posted. But I think there will be a lot of political pressure on hospitals to enforce that issue. Surprise billing is also a big issue, not just in the price transparency, but in letting patients know where their bills are going to come from. When they get the bill from the pathologist for the lab work that's done in the hospital, for example, and also when they are out of network and suddenly the bill for their physician is greatly exceeds what they anticipated under their insurance policy. Drug pricing will still be an issue. That was an initiative started under the Trump administration, trying to lower medications and how generics are handled. There are lots of issues coming up in telemedicine, and I think that will only increase. Medicare waived, or basically completely changed what it would pay for under telemedicine structures during the pandemic. Opened it up, in my opinion, in a very logical and reasonable way, which expanded access to Medicare beneficiaries during the pandemic without exposing them to either a physician's office or an emergency department or an urgent care office. So I think Medicare's changes were very helpful, although they were done as waivers. They didn't change the requirements. They just waived the requirements during the public health emergency. There were also some Medicare standards in telehealth that although they weren't even waived, they agreed that they would not enforce them. I think as the pendulum swung towards more leniency in the arena of Medicare, I think it was going to swing back in the enforcement range. We've yet to see whether the waivers will become permanent. Hopefully they will. And if the waivers are made permanent, I think that will diminish at least some of the otherwise expected enforcement activity in the area of telehealth. But watch for the areas which weren't granted a waiver but just weren't enforced. I suspect in those areas we're going to see some audits from Medicare, even retroactive audits during the pandemic, and that could give rise to some claims for false claims or even fraud. The last issue there, privacy and access to records, that's also a hot button. One of the things being debated now is information blocking as to what records, what parts of a patient's record the patient is actually entitled to receive. So privacy and access to records are going to continue to be a political and regulatory issue. What else should we expect? Like I said, enforcement of previously waived or intentionally unenforced regulations. Industry specific, I think we're going to see increased scrutiny of home health agencies, nursing homes, skilled nursing facilities, and telehealth. The OIG under the Trump administration began some reports on these areas, and those reports are due this year. And traditionally, when a report comes out and identifies problem areas, that is a trigger to enforcement in those areas. So I suspect those areas will see increased enforcement. And I left it off here by accident, actually, but I think hospice can be added to that list. Hospice used to be pretty safe. It is an honorable and respected industry, but there has been some recent, even under the Biden administration, there's been a recent criminal case that was brought against a hospice administrator who was colluding with others to basically come up with false diagnoses for patients, having them deemed to fit under the terminal illness criteria required by hospice and admitting them to hospice and collecting the funds for their care. Obviously, the folks, and I guess fortunately, were not actually terminal, so they were allowed to continue to billing them through the whole course of treatment. But they were discovered and now face criminal penalties. As we've kind of talked before, I also think we're going to start seeing once the reports are due for the provider relief funds, I think we will then see audits of those reports, and then we'll start seeing takebacks and penalties. So we're just waiting for those to start up. I suspect there's going to be some low-hanging fruit for the enforcement agencies there, especially with providers who closed their doors but did not return the money. I think that those will be the situations that are handled first, but then I think there's going to be increased scrutiny over the reports. I have not seen anything yet as to whether or not the government is going to try and say that improper retention of the provider relief funds equals a false claim. There is a concept of a reverse false claim out there saying that if you were paid money and you have the money and you intentionally paid money improperly, and you intentionally do not refund it to the government, that can also constitute a false claim. It will be interesting to me to see whether the government says that if you received provider relief funds, you did not use them in the appropriate way, and didn't return them, whether that constitutes a false claim. So that again gives rise to the treble damages. So if the practice received, let's say, $10,000 in provider relief funds, and the government determines that all $10,000 were improperly used, the government can then make a demand for $30,000, which is the treble damages, and they can also impose the fines and penalties. So make sure your reports are thorough and detailed, and follow the guidance from the government as you and when you submit them. So now that we've got kind of what to expect, what do you do? Doing nothing is really not an option. Obviously, you need to stay current with your compliance programs and policies, stay aware of changes in enforcement in your industries, and maintain relationships with your skilled advisors, because I do expect that enforcement will ramp up. That is everything I have. My next slide is going to include all my contact information. So if you do have questions, feel free to contact me by phone or by email. You could write me a letter too, although our street address isn't on there. But that's it for today from me. Buckle up with enforcement. Be aware of it. And as long as you are towing the line and you're doing okay, there's no need to lose sleep over it, but just be ready for this increased enforcement. Thanks again for joining us, and I hope you have a great day.